Good day, I'm Celeste de Haas from Remax Midlands. We are discussing an emotional topic that is very traumatic for the loved one that's been left behind. This is part 1 of a 2-part video, selling deceased estate property. It is well known that in South Africa, the sale of a property must be recorded in a written contract and must be signed by the purchaser and seller. The sale of a property out of a deceased estate is, however, more complex. Communication with all stakeholders is vital, and together with the executor, we as agents are responsible for driving the process so that no unnecessary delays occur. Ideally, the deceased would have made a will and appointed a professional such as a family attorney to be the executor of the deceased estate. Alternatively, a bank or a family member may be appointed together with an attorney. Once the estate has been reported, normally within 14 days of death, to the Master of the Supreme Court, the Master will appoint an executor by issuing Letters of Executorship. It can take approximately 8 weeks for the Master to issue Letters of Executorships, and no one has the authority to act for the estate until these are issued. The process, however, can sometimes be sped up. The executor has the task of winding up the estate of the deceased and is the only person who has authority to sign on behalf of a deceased estate. For an example, an estate agent's mandate to sell a property can only be signed by an executor. It is important to note that a sale agreement signed on behalf of the estate other than the executor is not valid from the outset, and the subsequent signature of an executor will not ratify the sale. If there is more than one executor, all executors must sign the sale agreement. Alternatively, a resolution by the executors empowers one executor to sign. This resolution must be executed and signed before the date of signing the sale agreement. The sale agreement includes a special agreement stating that the sale is subject to the approval of the master. There is a prescribed format which sets out the information required. The sale agreement must also be subject to prior written permission by the heirs of the estate. It is a legal requirement and is lodged simultaneously with the application of approval to the master. The format of this consent essentially means that the heirs confirm the selling of the property, the method of payment, and terms and conditions of the sale. Until these 2 consents have been obtained, there is no legal binding contract. Once the master is satisfied that there are no objections to the sale, permission for transfer will be granted. The extra requirements of a sale out of a deceased estate inevitably mean that there will be additional delays in concluding the sale agreement and taking transfer at the deeds office. It is important that a purchaser is advised of these delays and kept informed as matters progress, or not, as the case may be. We will hereby answer some questions on the ins and outs of buying property from a deceased estate. The first question: generally speaking, what do buyers need to know about buying a home from a deceased estate? Well, there are 2 major areas for a buyer to be aware of when buying from a deceased estate: the footstewards clause and the delays in winding up the estate. In a normal sale, the transaction is subject to a footstewards clause. In other words, the seller is selling the property as it stands. A more detailed understanding of this clause reveals that a seller will not be liable to a buyer for a patent defect. defects that are visible, nor for latent defects, a defect that is hidden and may only become apparent to the buyer much later on. The only defect that a seller will be liable for is a latent defect that he had knowledge of but failed to disclose to the buyer. In the case of a deceased estate, there is no one to disclose to the buyer, and therefore the buyer should take much more seriously his duty to inspect the property and become familiar with it, of the true state of the property, as he will not be in the position to come back later and claim back any damages from the seller or the estate. The delays in winding up the estate, although I don't regard myself as an expert in the administration of an estate, but I am aware that complications can and do arise that can delay the winding up of an estate. It is worth noting that an estate must be at a certain stage in order for the transfer to proceed. Second question. Does buying a property from a deceased estate take longer than an ordinary sale? And does the estate have to be completely wound up before a sale can go through? Well, there is no cut and dry answer. One element of an estate transfer that differs from an ordinary sale is the power of attorney has been endorsed by the Master of the High Court. In order for the Master to be in the position to do this, part of the winding up have to have been completed, but not all. The estate must be at least at the state where the liquidation and distribution account has been submitted to the Master. Leading up to this point alone can take a few months. Each transfer is different though, and each estate is different, so there is no definite answer. But in the best case scenario, the transfer will take a little bit longer than an ordinary one, and in a worst case scenario, up to a year. Our third question. Would a buyer be held liable for any costs that had been run up while an estate is being wound up, such as the levies, rates, municipal charges? Unless the offer to purchase stipulated that the purchaser is responsible for the rates and levies, which is not usually the case. The seller, or in the case of the estate, would always be liable for payment of the outstanding rates and levies. If the buyer takes early occupation of the property, he or she would be liable for the rates and levies. Contractual terms will be the guide for only his or her period that they've occupied the property, but the remainder will always be for the account of the seller or the estate. Our fourth question. Is it possible for a buyer to move in such a property before the sale has gone through? And if so, who would receive the occupational rent? The answer. It can be agreed in the offer to purchase that the buyer is granted early occupation from a certain date at a certain monthly rental. The money may be paid directly to the seller or estate, or to the transferring attorneys who will pay this over to the seller or the estate as agreed. So there you have it. Buying property from a deceased estate might be a little bit more complicated, but is possibly worth considering if the price is right. We also have available a step-by-step guide on reporting a deceased estate. So pop us a mail or a message, call us. We would love to hear from you. I am Dynamite de Haas.